On behalf of NCRC, National Community Reinvestment Coalition, I want to thank you for being with us today to join our conversation, our Just Economy conversations, preserving home ownership and wealth creation by addressing heirs property and tangled titles. My name is Jocelyn Matthews. I'm the director of the National Training Academy here at NCRC. We are joined with some amazing panelists that are going to be discussing the topic and leading the conversation today. So we have Scott Kanowski, Esquire Center for NYC Neighborhoods, Keith Wiley, PhD, Housing Assistance Council, and Natasha Moody from Housing Assistance Council as well. And I'll have you go to the next slide, Keith. So just a little bit about NCRC, if you are not aware of who we are and what we do here. Our mission is to make a just economy a national priority and a local reality. So we're a coalition of about 750 organizations and individuals dedicated to creating a nation that not only promises but delivers opportunities for all Americans to build and to live well. That's the core of what we do here at NCRC. If you're wanting to learn more about us and the work that we do encourage you to log into ncrc.org to learn more about us and maybe to even become a member of our organization. And I'll have you go to the next slide, please. So just a couple of housekeeping things for today and our conversation. Our code of conduct applies to all of our gatherings, whether in person or virtual. We do have those listed on our website under ncrc.org/conduct. What I will say is that we are all here with the main purpose of wanting to learn and gather information from each other. We're asking that people are respectful of other people's opinions and ideologies in the chat. We do have opportunity for you to ask questions of our panelists at the conclusion of our time today. We want to make sure that we're creating an environment where people feel safe to be able to share and ask questions, big or small, of our panelists, but also of each other. I also want to mention that internet, everybody is coming from a different internet, right? We're all kind of utilizing whatever we have, whether we're at home, we're at work, we're in a cafe, we're driving, we're walking, etc. So there may be a 5 to 10 second delay in all the slides, or you may experience temporary audio-visual lagging. That's normal. So we just ask that you are patient with us. If you have any other technical issues, please contact training@ncrc.org immediately so that we can be of assistance. And I also want to say, yes, so some people are already putting in the chat where they are, their names and where they're coming from. We would love for you to share that information just so we have a general idea of who's in the room with us and who we're sharing space with today. So please feel free to add that in the chat. And I'll go to the next slide. So here is what we're covering today. I'll introduce our speakers. We're covering heirs property and tangled title, research and methodology, and then some solutions. And so before we get started, I will just briefly share the bio of some of our panelists today. So first we have Keith Wiley. He's a senior researcher at HAC. He's worked extensively with many data sets in an effort to better understand where, when, and how development patterns occur. As part of these efforts, Keith has authored a recent article in the Journal of Housing Policy Debate entitled "The Role of the CDBG Program in Rural America," and has written several reports analyzing rural lending activities. He also co-authored both a book chapter in the Oxford Handbook of Urban Economics and Planning and the Resources for the Future Discussion paper exploring residential infill. Keith holds a master's in public policy from American University and a PhD in public policy from the University of Maryland, Baltimore County. Natasha Moody is a senior research associate at the Housing Assistance Council. She came to HAC as a Stevenson Fellow in the Applied Community and Economic Development Program at Illinois State University, where she completed her master's thesis on racial equity in the housing market. Natasha's current research projects focus on access to affordable housing in rural communities and the intersection of housing, land tenure, and the racial wealth gap. And then last but not least, we have Scott Kanowski, General Counsel at the Center for NYC Neighborhoods, previously directed the Homeowner Stability and LGBT Advocacy Projects at the New York City Bar Justice Center. In that role, Scott has trained attorneys, supervised cases of placed with pro bono and staff attorneys, provided direct legal representation to distressed homeowners, and engaged in law reform to preserve housing and communities. His areas of expertise include foreclosure, defense, and property law, heirs property and community stabilization, and deed theft and scam prevention and litigation. all with an acute focus on racial equity and social justice across communities. He is a graduate of the University of Minnesota with a BA in Portuguese and Spanish, and a 2001 graduate of NYU School of Law. He's worked at Morrison and Foerster in real estate finance law prior to transitioning to the public interest. Scott serves on the New York City Bar Association Mortgage Foreclosure Task Force and Nonprofit Organizations Committee, the New York City Attorney General's Deed Theft Task Force, and the New York City Nonprofit Legal Services Foreclosure Prevention Task Force. I know that was a mouthful, but that means that our panelists have a lot that they can share. They're well-versed in this topic and are looking forward to sharing this information with you. And with that said, I'm going to turn it over to Keith Wiley to get us started.
Thank you, and thanks everybody for coming. I'm Keith Wiley, and we work, just a brief introduction here, to the Housing Assistance Council. And Natasha and I work for the Housing Assistance Council. We're a small nonprofit in Washington, D.C., and we work on affordable housing in rural communities. We have four divisions. We have training and technical assistance, where we actually provide assistance to communities to build up their capacity and access programs like HUD and USDA home loan programs. We also have a HAC loan fund, where we have a loan fund that we loan money out on. We also have other programs we work with, like the Home Depot, where we do pass-through loans for veteran housing and stuff like that. In the research and information division is what I work with, and Natasha and I work, where we do a lot of research on rural housing and a lot of high needs regions, such as like Native American lands, lower Mississippi Delta, Central Appalachia. And then we also have a policy and advocacy division, where we work on promoting affordable housing in rural areas in the nation overall, but particularly in rural areas. And so we always refer to ourselves as hacksters and as hack, but it's thanks for having us here, and I'll pass it on to Scott.
Yeah, hi. Good afternoon, everybody. Again, thank you for joining us. This is a conversation topic that Keith, Natasha, and I are very passionate about. We're part of a whole national network of advocates and attorneys and folks who are involved in heirs property and tangled title work. So thank you for joining us. Yeah, I'm general counsel at the Center for New York City Neighborhoods. We're a not-for-profit, New York not-for-profit. We were organized in 2008 in response to the mortgage foreclosure crisis. And we do all kinds of advocacy work. We do policy work, research. We administer grants for legal services and housing counselors in New York City that are focused on homeowner stability, whether it's foreclosure defense or scam prevention or disaster relief, those sorts of things. And so we've been growing quite a bit. We probably have 100 staff members now, but we're all things home and community stabilization in New York City. Next slide, please. And just the center itself, we've served over 200,000 homeowners across the state. Served 31,000. Just last year, we served 31,000 clients, saved over 3,000 homes, and preserved $3.5 billion in neighborhood property value. The next slide, please. And we also have a wholly owned subsidiary, which is Sustainable Neighborhoods. And SN is also a CDFI, and it's an exempt mortgage banker and servicer. We just, through SN, we just administered the $500 million allocation of federal COVID relief funds to New York City homeowners. We did that as loans through our subsidiary. We have a variety of different loan programs, and most of it, it's all charitable lending, but we primarily do home repair loans through city and state agencies. We do some down payment assistance loan programs, disaster relief. And then we have several programs that are focused on foreclosure and loss prevention. Most of these loan programs are structured as non-amortizing interest-free loans that are low cost or no cost, and they just primarily sit as liens against properties. And then we recover those loans when the properties are sold or otherwise transferred, or if the term of the loan is finished, then we can collect that way. But we're not in the business of going foreclosing on those loans. It's all about foreclosure prevention. But that's sort of the main sort of lending programs we have, and I'll pass it back to Keith.
Yes, thank you. I'm just going to provide a little bit of background on the issue, and I probably won't use the right legal terms. There's a lot of law involved in this, when Heirs property is property that essentially somebody dies and the estate hasn't gone through formal estate planning and probate, and the land is essentially divided up among the heirs in its undivided interest. So if I had four brothers and sisters and my parents passed away, then we would each get a fifth if it didn't go through probate. So just kind of like that's the default option that oftentimes happens. But there can also be situations where somebody even wants to leave the land to multiple descendants, but still, again, they don't go through this formal transfer. And you've probably heard of this. So then like they have it and then say like then I passed on, then in without any formal, then it would go to their descendants. And that's how you can end up with properties that can have 20, 30, 40 heirs, essentially with an undivided interest. It's not like a divided parcel. So that's how you end up with heirs property and unclear title. Now, there's systematic causes for this, and one of the obvious ones is exclusion from the legal and financial system. We have a history of exclusion in this country through things like the Jim Crow laws and on tribal lands. And that can be direct exclusion, or then once that happens, there can be mistrust in the system, and then people don't trust it to work with it. And this is essentially a legal system where you've got to go through probate. There's also financial constraints. That happened where I grew up in a rural place. I don't know too many people that there weren't a lot of lawyers and they didn't have a lot of access to resources they would use to pay them. And you can also have legal and financial deserts. We deal with that a lot in rural areas. We worked with one time, a lady had told us it was 80 or 90 miles to the nearest place where they should get legal help. So these are some of the reasons why it doesn't go through that formal process. And there's not really financial support oftentimes available for people to resolve it, right? So there's all these different errors. So it takes money to clear that up then when me and my 4 or 5 brothers and their descendants are involved, and it's very complicated. And on the other hand, if my families wanted to save the property, there's also not the kind of access to resources, again, legally, where we could make that happen without jeopardizing our property and it ended up in heirs property status. And so one of the reasons why this is really important is, if you want access to a loan or a mortgage market, if you want to repair your home or you wanted to sell it or something, you can't really do that if there's no title. One of the federal housing programs require that as well. And that is one of the reasons why a lot of this has become more attention, because it'd be a disaster like Katrina and then people couldn't get access to services. And you also can't get access to stuff like insurance. So this is very important that you have a clear title to show clear ownership. Household implications. So I don't know why that's not showing up, but what happens is it puts families in jeopardy if they don't have they don't have title. They can't invest in their property, and they can always be at risk of losing their property. And it can also mean that people can end up being homeless, and also limits the amount of house. Oh, there it comes. Sorry, limits the amount of housing supply. It ultimately results in dilapidated and vacant units. I think we see that a lot, right? Because people can't invest in the property, then they don't, and therefore it becomes a vacant. There's also a loss of generational wealth. The number one way that people can make or accrue wealth and pass it down is through housing. So if you do not have that ability, then that also, and it exacerbates the homeownership gap. And one of the things that's oftentimes overlooked is the tax base in the community you're in. If the property falls in a vacant or dilapidated condition, it's not worth as much, then the taxes can't be collected on it if they even are, and that means fewer services to the people who live there. So it's kind of part of a vicious cycle. And I think it's also related to, maybe not directly, but tangentially related to things like outmigration and population decline, right? Where you have them occurring, you're more likely to have heirs issues, and it's just kind of like a vicious cycle. Familial land control is one of the ways that families might want to keep their land intentionally in the hands of descendants. This is another way. So the way I'm generally talking about is if you don't have the ability to do it, you don't have ability through access to legal services, but it can also be that you want to keep like the home place. in your descendants' care, and it can be a defense mechanism against homelessness in the legal system. It can also be like a communal approach to land stewardship, or like we talk to some of these families, they've been on a land for over 100 years, and it refers to cultural ties and political agency, stewardship, and kinship ties to the land. So you may choose this, right? So, and some people may not understand that, but you may choose to keep your land in this form. And again, though, it could end up in heir status if you don't have the resources to be able to protect it. I'm going to turn it back to Scott.
Yeah, and so we're an organization that works primarily in New York City. We do have some programming that extends throughout the rest of the state, but it's primarily New York City, as our name kind of indicates. The next series of slides, I'm just going to talk about the unique things that we've seen in the urban context as opposed to rural, and what are the major differences. And obviously, a place like New York City, almost all of New York City is developed at this point. There's very little vacant land, and it's almost all commercial and residential, and government uses and things like that. There's little, if no, timberland or farmland or anything like that. And so what we're really talking about in heirs property in the context of New York City is it's all around residential homes, and it's going to be co-ops, condos, 1 to 4 family homes, that sort of thing. And New York City too also has its sort of own unique issues around housing, because we've always had a housing crisis. There just aren't enough homes for the number of people that live in New York City, and so there's very limited supply. It's a very expensive housing stock. And so it's kind of ripe for the abuses and speculation and things that I'm going to get into in the next slides. It's a little bit different than some of the urban issues in other parts of the country. Maybe, Detroit is a good example of that, where there's a very high vacancy rate and a lot of abandoned homes, and the property values just aren't the same as they are in a place like New York City. Next slide, please. So I just want to give some historical context here, because when we think about heirs property, I think of it primarily as a racial equity issue. And disproportionately, the neighborhoods and the individuals and the homeowners and the heirs that we're working with are people of color, and it's all and primarily African American homeowners, residents, heirs, and it's just a lot of that is a result of historic and continuing racial discrimination that we're all should be very aware of. But we can trace a lot of the issues that we see on the ground today directly, back to, the ending of slavery in the United States. And so you had this Reconstruction era where African Americans were able to acquire a significant amount of land immediately, coming out of the war. But then we just saw a constant erosion of that getting that property, that land, and the homes. The Jim Crow era had a lot to do with that. As I'm sure everybody knows, the Great Migration. That's when northern cities experienced a lot of influx of former slaves and their descendants into our urban areas. The restrictive covenants, during all this time is sort of a reaction to migration into a lot of the northern cities. And this, it existed well before the Great Migration, but restrictive covenants on lands, for example, you cannot sell property, or maybe there's something written into a deed that says specifically this land or this home is only available for white Christians. We see that even, here in New York, we see some of these old deeds that still have those kinds of restrictions. The redlining practices as well. And the redlining was, restricting loans to only certain parts of a city. To take out a map of New York City, for example, and whoever it was would draw a line, a red line, and say you can't make any loans to anybody above this red line or within these red lines. And those are primarily, the less desirable parts of the city, and also where there are concentrations of African American residents. And so a lot of people are just locked out of the mortgage loan market because of the color of their skin. And it has major implications when you fast forward up to now, because, well, first of all, a lot of these properties in areas like Harlem in New York City the property values were artificially depressed significantly. And also, a lot of these homes had no mortgages on them at all. And you fast forward 50 years and it's still the same thing. You'll have heirs of grandma who owned the home, and there's a ton of them, maybe 20, and they're scattered all throughout the United States, but there's still descendants who are living in that Harlem brownstone, but it's an unmortgaged property. And because of the gentrification dynamics in New York City, those properties become targeted by the speculators because there is so much equity there. And a home that was artificially depressed in value at that time, maybe worth $30,000, now is worth $5 million. And so that's why these homes and these properties are being so heavily targeted. Eminent domain, I think that even still goes on in a lot of places but I'm not really sure. But this is where government agencies would go in and declare a certain part of the city. They acquired a part of the city and maybe put a new highway through primarily African American communities. That's a lot of what we saw. Robert Moses did that to New York City, where he'd take entire parts of the Bronx, for example, and just declare eminent domain and put in a highway and separating communities and breaking communities apart. The Fair Housing Act, 1968, that got rid of a lot of the discriminatory laws that existed, or restrictions and things like that. So a lot of the practices like redlining and other things are no longer permitted. But then there's, of course, all kinds of workarounds that you see have happened since. Reverse redlining, that's primarily what we think led up to the 2008 mortgage foreclosure crisis, where you now are looking at those same neighborhoods that are majority minority, and those are now the targets for the banks, because they see, or the lenders, subprime lenders and predatory lenders, because it's a lot of people in those communities who are locked out of affordable credit markets. And it's a way for these lenders to, make loans, increase their portfolios, but they're subprime loans, and they would package these and turn them into these, securities or that they then market, but they're just making really bad loans, led to that crisis. And so a lot of the work that we were doing at the center, for example, was assisting all those victims of predatory lending predatory and subprime lending practices. And then appraisal bias, like we've all seen this. It's something that's gotten a lot of attention, how a property that could, in all respects, would be two properties in all respects that are the same, even next door to each other. If one's owned by a white person, one's owned by a black person, the appraisal bias is that the black owned property is going to be worth much less on that appraisal, or it's estimated to be worth on that appraisal. But it's something that we're working on. But I want to play you this short video that articulates much better than I can what we're seeing in the urban context. So,
if everybody can see that.
I was born in the Republic of Panama, and I now live in New York. My father bought the house in 1979. It was a very lovely, quiet neighborhood. we really enjoyed being there. After my father passed, I was suddenly surprised one day when I received a letter from the Department of Housing telling me that there has been a transaction on my deed. So I went down there and found out that someone had placed their name on the deed. They sent me to City Bar Justice.
Fast forward 50 years and now you have these homes that are worth millions of dollars. So those are the sorts of homes that are ripe for predation.
To come to your house and have a sign on the door that says private property. When you call up the number on the sign, have the person on the other end say, I am the only one who owns this property. By the way, can I buy your interest in the property? But they do it and they're usually successful because most people in these cases can't. But our clients from the beginning refused to settle. They wanted to fight it. Tell me a little bit about what happened.
Truthfully, I don't know exactly what happened. Not at all. One day I'm cleaning up the house. Next day there's a lock on the door. All I know is I'm arguing with some people that say they own 50% of the house, and I just don't understand how. I need to stop this because it's destroying something that they don't understand.
You're up against a party that acts as if the court does not exist.
But you're affecting not just me, but my whole family.
The City Bar Justice and our Homeowner Stability Project, we are really focused on keeping those communities intact. And a lot of times they're lifelong homes. That's incredibly upsetting.
It really had a tremendous impact on me. I think we have an ally, understands the impact this has on.
You're helping people reclaim their dignity. And so what does that family home mean to you?
Everything. It means foundation. Where no matter how far you go, you can always come home. But unfortunately, there's no home no more. It's still rocky, but it's easier because we have somebody backing us.
So there's also, with that video, there's some really nice music in the background and other things, and it cut out a little bit just
Born
because
in
there's
the
a
Republic of
a
Panama.
technical lag. But that's basically the story of two of my former clients when I was at the City Bar Justice Center. And we're just working with pro bono partners to get them legal services to help protect our homes that have been preyed upon. And I'll get into that more in depth in just a moment. Next slide, please. Yeah, so what is predatory partition of heirs property? It's a predatory investment practice that forces partition by judicial sale, stripping equity. It's basically a lawsuit brought in court where you get a court order that mandates the sale of the property. It's a tactic that was first identified really in a rural coastal South. It was used by developers and places like the Gula Islands, where you'll have land that had been Black owned since the Reconstruction era, and there may be 100 or more descendants or heirs, and the developers would target that because it's very prime real estate for golf courses and resorts and things like that. And they were able to go and find one long lost heir somewhere, and they would acquire their interest, their fractional interest in that property that they acquired, through just by operational law, through the laws of intestacy, meaning that nobody ever dealt with the will or dealt with the estate, and now it's just fractionalized ownership amongst a large number of relatives. But if they were able to acquire even a small interest in that, they could bring a partition action, and they could force a sale of that property. Usually they were the only bidders. It was again depressed value. And the interests that they acquired to begin with were probably much less than what those interests are really even worth. We began to see this practice in New York City about 6 years ago. I'm sure it had been going on long before then. But it was when I was still doing direct legal services, and we deal with all kinds of scam prevention. And several people came into our project describing this and what was happening to them, and somebody living in their parents' home, and they had 2 siblings, and the siblings sold their interest in this home that's maybe worth $1 million to an investor for $100,000, a speculator, based on misrepresentations that speculator had made to those other heirs. And so then you have the speculator acquire those interests, and they bring the partition lawsuit and force the sale through the courts. And I didn't know anything much about partition law when I started seeing this practice, and I just started reading through the case law, and it's terrible. It just traditional partition law is just really super onerous. And so we saw what was happening in New York City. We got a lot of publicity around it. We were connected with Thomas Mitchell, who had worked on some law reform efforts in this area, but mostly focused on rural areas. I mean, it was applicable to everything, but the real focus was what was going on in historically Black held lands in the rural South. But the speculators had basically used these successful tactics there and transplanted them to high value properties in New York City. And I'm sure this happens in many other places, or we know it happens in many other urban areas. But it is theft. It is equity theft. When you're stripping, millions of dollars worth of wealth held in this home, just with, deceptive business practices primarily. And it's just people that don't know their rights, don't have access to legal services to adequately advise them. They don't have access to capital markets, or they don't have access to credit because of historic, again, discrimination, or just insufficient income or insufficient resources and all those sorts of things. Next slide, please.
Hi everyone, Natasha Moody, Housing Assistance Council. So as Scott was just mentioning, the predatory partition sales, there's an article that's published in the Brownstoner. I can drop the link in to the article in the chat, but wants to highlight a very specific example that happened in Brooklyn also because it's a very, very sad story. And we also use some examples from the situation throughout the presentation. But this home was purchased in 1940, and it's since then 4 and 5 generations. This is the 4th and 5th generation currently that we're living in the home, Philippa Doyle and Aisha Doyle. And so for 75 years, this home had been in the family, and the deed was last in Philippa's mother's name. And upon her death in 2017, Philippa thought that the executor of her mom's will had probated the property, but the property was not probated. And so Philippa and her brother both had undivided interest and claim to the home. Philippa and her daughter Aisha lived in this home. They had paid off the mortgage, paid all the bills, maintained the home, did all the upkeep, and planned to have it for future generations. But in 2017, the Doyles received a call from an investor saying that they had purchased interest in the home. So at that point, they looked into it, realized it had been probated, and decided to try to probate the property to clear the title. But Philippa could not get in touch with her estranged brother, who they think was living in Australia at the time. The investor claimed that he purchased 75% interest in the home for $300,000. And so this investor attempted to force the sale multiple times, and eventually, after many years of fighting, the home was sold earlier this summer for $1.7 million. And so the Doyles are faced with a situation where they've already spent a lot of money fighting this legal battle from 2017 through 2024. And now they're facing the question of where do they go? Because this has been their home, and they intended it to be their home. They didn't anticipate it wouldn't be their home. And so they're facing now housing insecurity because of the theft that Scott just kind of highlighted. And so with that, I'll actually turn it back to Scott.
Yeah, and thank you for that, Tasha. It's a great illustration of what we see over and over and over again. I mean, these aren't isolated cases. You scratch the surface and you realize that it's been happening for a long time, and we're talking millions, billions of dollars of wealth that is being appropriated and transferred out of the hands of communities of color into speculators. These two gentlemen, well, there's a third, we kept seeing their names popping up in these predatory partition cases and people coming in and seeing their names. And so I contacted one of our investigative reporters that we work with on certain kinds of scam prevention things. And what they uncovered astounded even me, and I'm pretty jaded. I see this stuff a lot. So these brothers had managed to acquire about 120 properties all throughout New York City, engaging in this exact practice. And it's primarily, as you can see in the map here, in communities of color. The value of their acquisitions were probably around $150 million total. So they built a little real estate empire by engaging in these practices. They would set up LLCs, limited liability companies, to hold the properties. It's much harder to trace who owns the property. If there is an LLC, you don't know who the members of that LLC are a lot of the times, but the investigative journalists were able to figure out and connect a lot of these LLCs together. I'm sure there's a lot more than just this 120 properties. But we see a lot of the same actors, a lot of the same speculators involved in these transactions. Next slide, please. So what's been done nationally to address the predation of heirs property, and also what has been our approach in New York? I mean, the biggest thing out there that we all need to do is it's public awareness, just getting heirs, anybody who owns an interest in a property like this, or anybody who owns property and they want to make sure that their property doesn't turn into heirs property. It's just getting the public aware. It's either through news or through conferences, seminars, webinars, being out in the community, putting stuff on the radio. Those are all things that we've done, going to churches, going to senior centers, and just educating the public about this practice and what they need to do to avoid or deter it or fix it. Estate planning and legal resources. There's been a lot more focus I've seen in the last 5 years on providing estate planning and legal services to low-income homeowners, low and moderate income homeowners. And it's so important because these homeowners need to have an estate plan in place to avoid the property turning into heirs property, whether it's a will or a transfer on death deed or some plan. But people just need to really think about that. Homeowners really need to think about that, and they need those sources. And also the legal resources when somebody has passed away. They need somebody to assist in probating a will or administering an estate, or preparing heirship deeds and affidavits, or even litigating these predatory partition cases, for example, or quiet title actions, different things like that. One of the biggest law reforms in this area is the Uniform Partition Heirs Property Act, and I'm going to go into that in a little bit more detail in the next few slides. And then there's other just legal and systemic reform, and we've all been engaged in this, and making sure that a property that's experiencing tangled title, they get access to the other, you know, government benefit programs or like relief programs and things like that. When you have an heir who is living in that property, ownership interest, and traditionally they've been locked out of a lot of these programs because of the tangled title issue, or there's not a clear record of title in the land records. But again, a lot of this is just around rules and local rules and regulations and expanding lending programs to be heirs property aware. The next slide, please. So the Uniform Partition Heirs Property Act, it's been a very, very successful uniform law. It came out of the Uniform Laws Commission in 2010. Again, Thomas Mitchell, who, you know, we all revere as the real expert here, and who's, you know, kind of worked tirelessly forever in this law reform era. But he was involved in the committee that promulgated this uniform law. It's now been passed in 24 states, I believe. Yeah, and it's been introduced in 6 others. But the key features is it's trying to level the playing field here for the heirs against, you know, well-powered, well-moneyed interests. It requires a posting of a notice of lawsuit on the property. You know, traditionally, a lot of these heirs had no idea that that an interest had been acquired and a lawsuit had even been commenced. It's a court determination of appraised value. This is, you know, if the court is going to divide the proceeds or permit somebody to purchase an interest, it's the court that's going to determine that value. If the parties can't agree on what it is, there's a co-tenant buyout with the priority of to the holder's interest. There's a preference of partition in kind. So basically, partition works in 2 ways. You're either going to physically divide the property, so you have like 100 acres, and you have 2 heirs, so you give, or 2, you know, tenants in common, you give each heir 50 acres. That's partition in kind. It's just a division of the property, you know, based on whatever their values are. But there's also a partition by sale, and that's become sort of the default in traditional partition actions, because it's just so much easier. But it was a problem in rural areas because primarily because a property that was subject to one of these lawsuits, there'd be a court-ordered sale, but then the purchase price of that sale would be very, very, very low. So we're seeing this equity being stripped from the property because of the partition in sale default, as opposed to if you say you have, you know, heirs who are farming or working a part of the land, they would just, if it was partition in kind, they would just carve out that part, their share of the property, and they would give it to them instead of them being displaced from their land. And then there's just a few other things, like a preference for an open market sale. In New York, we never had that really written into law, where it could be a brokered sell instead of a forced judicial sell. Next slide, please. So in New York, because we have sort of unique issues on the ground, working in an urban environment, and that's where we're seeing this predation happening, we changed or modified a lot of the standard uniform law. We got ours enacted in December 2019. It was in response to some media coverage that we got, just showing the extreme inequities of traditional partition law. But among the key features of our law is that we expanded the definition of heirs property. So basically, anybody who even lives in the property, if they're an heir, now it's considered heirs. If even if they have a small fractional interest, it's considered heirs property. The unmodified law had a really high threshold. I think it was something like 20%. It provides for our version provides for mediation. It's alternative dispute resolution, and that's a court monitored process where the parties are required to sit down and negotiate in good faith. to find a solution to try to preserve the property's value if they can. Our version of the law, it permits a second opportunity to answer the lawsuit and put in an answer to the complaint. This is again is like highly legally technical, but what we were seeing in the foreclosure context primarily, but also in this context is, somebody served, somebody who doesn't have any experience with the legal world is served a complaint, and the complaint says you have 20 days to put in an answer. They typically just have no idea how to do that. And so we're seeing really, really high rates of default in the foreclosure context. And so what we did there is that when we have these settlement conferences, which we wrote into New York's foreclosure law, and now we wrote into the partition law, the court is required to explain to these unrepresented heirs that they have another opportunity to put in an answer after the start of these conferences, so that they're not in technically default under these lawsuits. Because if you send a court notice to somebody that says, show up at the courthouse on this date at this time in this room, they'll almost always show up. When you have like this really complex legal document that says you have 20 days to put in an answer, nobody knows how to do that. The other good thing about these settlement conferences is it's an opportunity to connect unrepresented heirs to legal services who can assist them in preserving their rights. We wrote into our law that an heir occupant has first priority over everybody else. It's to maintain community ties and keep people in their homes, keep people in place in their communities. And this doesn't depend on this priority. This buyout priority doesn't look at what the percentage interest is. It looks at your occupancy. And then the next level of priority goes to other heirs who may not occupy the home, and last to the third party that had acquired that interest. And then finally, it permits the court to look at all the equities. I mean, equities just means all the different factors that inform the fairness of what's happening, whether or not it's fair that this investor who paid $10,000 for this interest, that's $1 million, is able to now demand $1 million to sell their interest back to the family, somebody in that family. Things like that. It's now explicit in our law that the court can look at all these different factors. Like, what did the speculator offer to pay? What did they tell the other heirs when they were acquiring these interests? Did they make any kinds of misrepresentations? Were they harassing the holdout heirs to sell their interest and like banging on their door every day? Things like that. Next slide. So we just got another major improvement to New York's law passed this year. It's the New York Heirs Property Prevention and Deed Theft Protection Act. And it really, so New York is already a leader in, our version of the Uniform Partition Heirs Property Law. We kind of took it to the next level, and now we've taken it one further step. Now our law, it prohibits non-heirs, these third-party investors, from even commencing the partition action. It's not taking away their property right. It's just saying that you can't go to court to force a sell or anything else once you've acquired this interest. So you're gonna have to work with that homeowner in some other way. Otherwise, your interest is just gonna sit there. You can't employ the courts in your scam. It also it provides heirs a right to purchase the interest on the same terms that third party had bought it. So if the investor bought interest for $1 million interest for $10,000, now the other heirs have a right of first refusal. Basically, those heirs have a right to purchase that interest on the same terms and conditions as that third party. And then the other parts of this great legislation is they included a new deed theft criminalization provision, so it gives more authority to the Attorney General and the prosecutors to go after the really bad guys, the ones who are committing fraudulent acts. And then we also included a transfer on death deed, which is a special kind of deed that assists in estate planning for people of low to moderate means. And basically, you would prepare and record a transfer on death deed in the land records. And so the interest automatically transfers to whoever you name in that deed when you pass away. But you still have full ownership of that property when you're alive, and you can also still transfer. You can take away those. You can rescind that deed, or revoke that deed until the time that you die. Next slide, please.
Yes,
Sure.
thank you, Scott. I'll just take over here and talk a little bit about our study. At HAC, we did a national study of heirs where we tried to get just like a baseline account. And first slide here I want to show is I just want people to think that we think we're the one that's created this. There's been over 40 years of research done, and here is some of the studies. We really stand on the shoulder of giants, from Dr. Cassandra Johnson Gaither to Connor Bailey and Dr. Ryan Thompson at Auburn. There's a lot of people, Professor Heather Way, that have done a lot of research on this. And so we really kind of used that over the last 40 years to try to help inform what we did. And so I just think it's important. And there's a lot of information out there. It's very good. And there's a lot of work still going on by a lot of really good people. Now, next, our methodology that we used was we have owner characteristics and property characteristics. We used a two-step approach. So one, we took a tax assessment and deed data, a large file that was provided by I think it's ICE. Where they collect all the property tax assessment records, and we essentially searched through the names for owner characteristics that were strongly suggestive of heirs. And so those we could identify as heirs, as if it's different interests in the property, if it's really kind of spelled out. But then we realized that would be an undercount. So then we also looked at property characteristics and characteristics that might be associated with heirs, like it hadn't sold in 30 or 40 years, like, it had poor building quality and condition. So we used them both to create a most likely, which is the owner characteristic heirs, and an at risk, which is property characteristic. And then we added them together for essentially an estimate of heirs that we created into a percentage, which you can see in this county map here. So we had, like, say 100 residential properties, and we had 20 that were either most likely or at risk. So we calculated a percentage and we created a prevalence. And this is very conservative, and there's a couple of things I want to point out. We had an estimate of 580,371, or about 0.6%. And this is residential properties. We didn't use farmland and stuff like that. We're going to get into our vacant lots. We had a value of about 32 billion. Again, it's extremely conservative. And you note there's several gray states on here. Those are states that we had some data issues with, and I'm going to talk about them in a minute. But those are states for which we were concerned that the data was not exactly the most perfect. But you can see it touches the one good thing about this map is I think it shows it touches many communities. And it's very conservative, but I think, it touches pretty much every state. This is an issue and a lot of times don't think people understand that. And one of the links we found, in this is related to some other slides, persistent poverty areas, and this is a map of them using one of the definitions, which essentially is it had 20% or higher poverty rate in county for the last 3 decades, so it's chronic poverty. So we found that there was a higher share of heirs properties, about 1.2% compared to 0.06 in the other counties. So in other words, there was just a much higher prevalence of heirs in those counties, and that makes some sense, right? If it's part of economic distress, it's kind of like just part of the cycle then, and you end up with these heirs properties, then people can't invest in them, and it kind of drags the community down, and it kind of hurts the family as well. And they're primarily they're at risk of losing their partial, but then also they are unable to pay taxes, and the property goes into a dilapidated state. So it's kind of one of the things we think it's contributory to. Now, here are the 6 states we omitted, and I just want to talk about this because I think it's important. One of the nice things about our paper is I think more than necessarily a baseline number is it lays out an approach that I think other people can do. But first, I want to note up front that we had some issues with states with omitted data in Kansas, Maryland, Vermont, Wisconsin, and Wyoming. What we did was we looked at the most likely and the at risk, and we identified areas where they varied dramatically. And that was areas we were concerned that our count would be wrong, or not necessarily wrong, that it was just wildly too much variability. So when we in turn contacted people to see the issues that might be arising, and that's the reason why we then omitted some of these states, because we were uncertain. And just to highlight that, this is New York, and just to show you some of the issues we had here. And you can see the ICE number units are the residential properties we had, and then the US Census is the estimate of residential properties. So you can see we were missing about half or a large share of them in our data set. Now, in this case, and you can see for the Bronx, Kings, New York, Queens, Richmond, the different boroughs. You can see that it varies. In the case of Kings, it's like 195,000 compared to 1 million. And so what we think was going on is a lot of these are in co-op status and stuff. So our records are counting them as one, which means we were grossly undercounting them. And these are the kind of issues that come up, right, when you do this kind of research. And so that's why I think it's actually probably better to do it on a smaller level, on a local level. And here's just some of the considerations, and I'll get into that here. Ours was very conservative because what we did was we tried to apply it to every county. So if we knew there was a term or an approach that might not work in one county but work in another one, we generally didn't include it because we were unable to specify it. So that would mean we would exclude a lot of cases. The data varied by county and state, and we think in particular our approach was better for rural areas where it might not work in urban areas, i.e. the condos and co-op properties. We think further regional research is needed. I think this is one of those things where, like, if you're working in a 2-county or 3-county area, that kind of research would be better, and then we could specify and understand that in the Southeast and in like North Carolina, Georgia, this is how it might be done. And this is because remember, there's 3,142 counties, and there's tax assessors in each one. They do it differently. Our research did not look at vacant and farmland. We concentrate on residential, but that's an important thing. We did not have race or ethnicity data, which is really important, but we did not want that. But that's the reason why you can't really say anything, because you may have a county with a relatively small portion, say, of Native American residents, but all the heirs property may have been in that community. And our estimates were sensitive, particularly on our at-risk category, to how we varied the measures. We think that's also related to how data was collected around things like housing quality and stuff. It varied considerably. But I think, those are some considerations and things. And I think, if you do a more localized approach, you can probably address those. But I think it's important to understand, have at least an understanding of how many people you might be addressing. It's important. It can help you with advocacy and certainly on grant applications. A lot of times people don't just like to hear, I think it's a problem, or I'm pretty sure it's a problem. If you can we think it's at least this magnitude is really important. Considerations and risks, or if you put this at the census tract level, then nefarious characters like Scott had talked about could say, okay, there's an opportunity. There's minerals there that we can extract, and we could buy this land from people and force them and get a cheap sale. So you put people at risk. It's like a, Hippocratic oath type situation. So you've got to be very careful of doing that. The data, there's going to be issues with it. And so you need to know that and understand that. And whenever you do this kind of research, understand there's going to be limitations as well. But that's kind of, I think it's important to do that as a baseline. And I'm going to turn it over to Scott again.
Thank you, Keith. Yeah, so at the center, we have been also trying to quantify the extent of heirs property in New York City and New York State. And, as Keith mentioned, their report excluded New York for various reasons. But we just don't know really the extent of heirs property. I imagine it's in the billions of dollars. But we were funded by Wells Fargo Foundation to do some preliminary research to just wrap our heads around this question. And what is the extent of heirs property, and what is the extent of loss of heirs property in New York due to various factors, not only predatory partition, but a sale, like a foreclosure, for like a reverse mortgage loan when a homeowner dies, or foreclosure for property taxes, or the house falls into disrepair because of some disaster and nobody could get any relief funds or home repair grants or things like that. So anyway, we conducted a study over a 5-month period, just looking back at how many, looking back at all the partition lawsuits that were filed. It's really just a starting point for our research. But one of the things when we got the Uniform Partition Heirs Property Act enacted in New York, we also got the court to modify the form that you file when you bring a lawsuit, and now they have to indicate whether it's a partition of heirs property. The plaintiff, the party bringing the party, has to indicate if it's a partition of heirs property case. And so now we can track these cases. We can go back and look at all the new filings in the court system and determine if it is heirs property. It's not fail-proof, because a lot of times the party bringing the case will not indicate that it is heirs property, but we can usually figure that out as well. So we went back and looked at a sampling of properties, partition cases filed in New York City over the last 5 years. Not 5 years, 5 months. And just to get some preliminary results, to get some preliminary findings to understand that scope. We intend to go back and look at all the cases that have been filed since the UPHPA was enacted. Now we're able to do so, and maybe even extend this research further. The new law that doesn't permit these partition actions to even be brought by these third parties didn't take effect until July. We do know that these parties are filing new partition lawsuits, even though the law now says they can't. So that's another part of the research that we're going to, try to engage in. We need more funding for that sort of stuff, resources to do that. But that's kind of where we're going with this. But the methodology is we look at the cases that have been filed, we pull out the property address, we look up to see what an approximate value of that property is. And then we also collect other information, like who's the actor, who are the actors here, who are the firms bringing these lawsuits, who are the investors, speculators, and just pulling all kinds of data out of those cases. Maybe the next slide will be helpful. I'll just give you these preliminary results. This is ongoing research, but just for a little more background, what are we talking about in New York City? There's 8.3 million residents in New York City with 3.5 million housing units. Probably about 60% of that is rental. The other 40% is owner occupied owner occupied. Of that, just over 300,000 are condo units, 450,000 are co-op units. Co-ops are very kind of unique to New York. They do exist in other states, but they're primarily in New York. And co-ops, for example, aren't real property. That's how they're distinguished from condos. They're still in a multi-unit building. But when you buy a co-op unit, you aren't actually buying the real property itself. You're buying shares in a corporation that have been allocated to a specific unit in that building. And then you're entering into tenancy with the corporation. So you're wearing two hats as a co-op owner. You both own a share of this corporation, but you're also then renting a unit from the corporation. So co-ops have all kinds of different problems. And I think, as Keith had mentioned, that's one of the units one of the kinds of property ownership that was really hard to identify when they're doing their study. We have about 450,000 single family homes and 740,000 2 to 5 family homes. Next slide, please. So what are the key preliminary findings here? The research period was just over 5 months. Out of that, we pulled out 182. Well, when I say we have this really great research team at the center who just really did the deep dive into these cases. So they're the ones who are responsible or should be credited for these preliminary findings. But they identified 182 likely heirs property cases. Estimated mean property value was over $1 million. The combined property was $200 million. So we're just talking about a very small sliver of heirs property in New York City. And it's only those heirs properties that have already been targeted by a speculator, that speculator has acquired an interest, and they're bringing a lawsuit. And so these are the ones that are at the most critical, have the most critical threat of being appropriated, of having the equity lost. And so that's why we're kind of focusing on these ones to begin with, so that we can quantify the loss. But also by looking at these cases, we can also make sure that the heirs are getting representation, that they know their rights, and all the other good things. But what heirs property are not being identified by our research here? There's a ton of heirs property that is just sitting there, and it's been sitting there for decades, that, that's really hard to understand or find. You'd have to do some sort of combination of looking at death records and comparing that to the title holders. And there is a way to do it. We just need to create that model or figure that model out. So that's all a work in progress. Next slide, please. So out of this small sample, most of them are in Brooklyn, which is a very, very high valued borough now, a very large borough. Borough is in New York City, aligns with, it's a political subdivision, aligns with counties basically of Kings County, which is Brooklyn, Queens County, Queens, New York County, which is Manhattan, Richmond County, which is Staten Island. But this is the distribution. So we're seeing most of this predation going on in Brooklyn and Queens, where there are large areas of, historically minority neighborhoods that have rapidly gentrified, and that's why they're being targeted so heavily. And Manhattan has very, very, very high property values, but not as many communities of color like the other boroughs do. Next slide. So estimated mean property value, 1.1 million. Average New York City home value is almost 900,000. Half of the cases in our sample study are in areas with above average home values, which kind of goes to what I was just saying, where you have these rapidly gentrified, historically minority neighborhoods. Next slide. The income levels of affected properties, 43% are located in areas where median homeowner income is below average. So you'll have a very, very valuable home. The heirs and the owners are lower income compared to the rest of the city. Next slide. Age demographics. It looks like about a third of these homeowners in the study are, I'm not really quite sure what that means. 55% of heirs property cases in areas with an above average percent of homeowners. So the properties being targeted are disproportionately held by seniors. The heirs are disproportionately seniors, and it's because a lot of these, a lot of the individuals who are dying or passing away, who are the homeowners, they're being taken care of by their adult children who also live in the homes, and so there's just a strong correlation there. Next slide. And then racial demographics in heirs property cases. So we were looking at census tracts and comparing that to the sample study. About 60% of the cases are in areas with above average percentages of non-white homeowners. Next slide. This is just a summary of the findings. Half the cases in high value areas, heirs property affects lower income households. Older homeowners are more affected. Non-white communities are heavily impacted. Again, this is a very small sample. Next. And the key takeaways is we need more outreach, education to prevent heirs property, more estate planning services, partnering with local organizations to implement best practices, and most critically, the financial and legal support. Next.
So after we conducted the quantitative research in collaboration with Fannie Mae at HAC, the question is kind of what's the role of the housing and housing finance industry in this? There's been so much amazing work done in the legal space, in the agricultural space around this. There's a lot of local initiatives to support residential heirs property owners. And so looking at what are some of the things that on the national level that the industry can come to collaborate and to support heirs property owners. And so one of the areas is that when it comes to buying out other heirs, which Scott mentioned that earlier, and that was the situation with the Doyle family where someone had purchased the interest, and there may be an opportunity for the heirs to buy back the interest of external partners or buy the interest of other heirs to clear the title. So next slide, please, Keith. Thank you. And so, looking at the housing finance industry, the question is, can we create a product to meet a need that there currently isn't a form of capital available to pursue this? And so when an heir wants to buy out another heir, there is no funding available for that or a product like that on a national level. So is it possible for our industry to create a buyout loan that is viewed as a long-term property purchase loan? And so in the case of the Doyle family, where the investor purchased the shares for $300,000. If the situation had played out, which is a provision of UPHP that Scott had mentioned earlier, if the Doyle family had the option to buy back the interest of that outside investor for $300,000, very few households in this country have $300,000 in cash laying around to be able to do those types of purchases. But it may be even as small as $10,000, and I say small with quotations, in some areas with lower property costs, but a lot of families still don't have that kind of cash. So can we create a product where it's a long-term, this is the lower interest, long-term loan that folks can use for this buyout loans? Next slide, please. And so also there are homeowners who want to clear their title and also may need home repairs because, let's say, for example, they have not had clear title for a while, so they weren't able to access the housing finance repair monies, whether that's through financial institutions or for federal monies. And so now they're looking to clear their title and repair their home. Is it possible for our industry nationally to create a product where there's a housing repair loan and then there's an attachment of the funding needed to clear their title? So Scott had mentioned how, there's so much amazing pro bono work and legal services, that legal aid organizations that provide these services. But in some of our communities, those services are not readily available. They may need to use private attorneys and pay those attorney fees. Even if there is legal aid, there's still some court fees that may be aligned there, or some other fees that they need to pay for. So can we use the capital in the housing finance markets to support heirs property owners by expanding the type of eligibility for products? Next slide, please. And so I just want to mention quickly, in the interest of time, that as I was mentioning, that particularly for our rural communities, since HAC works in rural primarily, that just want to highlight that there are many legal deserts. And so when we think about pathways to capital, if the barrier still is they have to clear title first, that is not an option in communities where there is no attorney in the entire county. And so only 2% of attorneys, and it's all types of attorneys, work in rural areas. And this data comes from research from the Legal Services Corporation. Just want us to keep in mind that as you think about products, we need various types of products because heirs property issues present in many ways. But particularly when we think about, we want to support those who have the ability to clear title, to have the funding available to do that. But there are communities where clearing title is not an option. And so next slide, please. And so we will just go to the next slide after that as well. Thank you, Keith, for the interest of time. And so we want to look at, we know that there's some initiatives on the local level being able to do this. So on the national level, can we consider giving housing repair monies and lending on demonstrated partial interest? If, for the example, with the Doyle family, I'll just go back to that because you mentioned that, if she can show, like, I have partial interest in this property and I really need access to housing repair monies, can we figure out ways in the underwriting process to think about collateral a little differently and how that ownership can be demonstrated to be able to access, in some areas, much needed housing repair monies? Next slide, please. And so I'll just want to highlight quickly that heirs property, as both Keith and Scott mentioned, are one symptom of a systemic issue. And so while we're thinking about products for to support heirs property owners, if we are creating products within current lending practices, we have banking deserts. We have lower lending rates in some areas. There are folks that are unbanked. There are folks that do not have equitable access to the current products that are on the market. So just thinking about even as we're creating and thinking about heirs property products to support heirs property owners, there's still a need to think about where other barriers may exist in certain communities. So in the interest of time, may I request that we skip a couple slides here, so we can go next slide, and next slide, please. Next slide as well. So just want to highlight rather briefly that there are many benefits to preserving and helping to resolve the issue of heirs property, both for the families and for the communities. And so it's a value that we want to protect the wealth that Scott and both Keith and Scott had mentioned, but also when there are concentrations of heirs property, there are also implications for that community. And so having some of these many solutions that Scott mentioned and considering some of these housing finance products, there are benefits for both family and community. Next slide, please. And I'll just highlight here very quickly that there's been a lot of work done in the legal space and agricultural space, and then there's a lot of local amazing work in the housing space. And so a collaboration across all of the sectors to be able to figure out how we work together to move this forward and how housing can learn from legal and agriculture is really important in this space. Next slide, please.
All right, and then I'm going to keep this fairly brief because we want to give a little bit more time for folks to ask questions. But so our CDFI Sustainable Neighborhoods has done a lot of work in creating a model in how to address these heirs property issues. And it's mostly around lending. And it's just how do you get a source of capital that's recoverable that you can deploy to address this issue. Next slide. So real quick, and Natasha already mentioned this, it's really to consolidate ownership, prevent foreclosure, whether it's like a reverse mortgage loan or property taxes, prevent scam, speculation, keeping people in their homes and communities, preserving critically intergenerational wealth, especially within Black communities where a majority of familial wealth is held, and then just addressing that racial wealth and homeownership gap. Next, please. So we, through our subsidiary SN, we already have a lot of existing lending programs, and some of them we can even and already have started to deploy to get funding for individuals who are largely locked out of traditional credit markets. So the Equitable Retention Mortgage Assistance Program, that's designed as non-amortizing, no interest, no cost loans. So those loans, we just give the money. Right now it's up to $50,000, and that just sits as a lien against the property. The homeowner doesn't pay any monthly payment or anything on that. But if the homeowner sells their property or refinances, then they have to give us that money back, and then we can redeploy it to the next person in line who needs that money. Our distressed mortgage relief program, that's set up as a traditional convention mortgage loan. It's just, they're affordable. They're very low cost loans, but there is interest that's earned on those loans, monthly payments. That money then we can also redeploy. We've closed that program for lack of capital. We've only made maybe 20 loans under that program. I want to talk about the New York State Homeowners Assistance Fund. That was federal COVID relief funds. That's sunsetting. We're at the very end of that program. That was $500 million for homeowners affected by New York homeowners affected by COVID. Those are set up as 5-year forgivable loans. Again, there's no interest, no payments. After 5 years, they completely go away. The requirement there is that the homeowner has to live in that home for that 5-year period. They can't sell the home. If they do, then we can recover that money and redeploy it. So it's been very successful. So far, I think we've gotten about $8 million in repaid funds that we're able to redeploy. Other potential programs, home repair programs have been problematic because a lot of the city and state agencies, they require very clear title in order to make those loans. And so heirs property and table title have been locked out. So it'd be great to develop a program. We're kind of working on this right now to extend home repair loans to heirs property, to owner occupants who live in the property. Down payment assistance, sort of an opportunity to consolidate. Let's say you're an heir living in your family home. You need, $200,000 to buy out the interest of the other people. You've never gotten a mortgage loan before. That's a creative way to get a loan and consolidate interests. And then we're working on developing other programs. Next, please. And this is just a comparison of the IRMA and the DMRP models, just to get that. And I think that's the end of my slides. So we have time for questions and answers.
Thank you. A huge thank you to Natasha, Keith, and Scott for sharing with us today. I know that there's a lot of interest in this topic, and so I want to be able to jump right into questions. So if you do have any questions that haven't already been put into the Q&A box, please feel free to do so. I know that Scott and Natasha have been able to answer a couple of those questions, but some I'll just raise here as well. So first question is, can you explain in more detail how partition lawsuits work? Do they essentially just say, well, it's contested, so you both must sell, but only the spectators have the money to buy?
Well, partition lawsuits are very, very complicated, and I don't think we really have the time right now to delve into it. But what was happening before we got into these law reform efforts was that the third party would buy the interest, they'd bring a partition action. It was never contested because the heirs had a lot of times didn't even realize the lawsuit had been filed because they weren't served adequately. And the court was just rubber stamping these lawsuits on default. And so the speculator could buy the property for their interest for $10,000 and walk away with $1 million property for $10,000. But yeah, we've done a lot of presentations on the intricacies of partition law and how that's all changed. So it's probably better for another full CLE or full seminar.
Another question is, the Great Migration highlights some of the unique challenges many Black families face today with land still owned in rural southern areas where mineral leases are still active. How can families who inherited land in rural areas, often as property, navigate the financial and legal constraints of outdated mineral leases that provide low fixed royalties?
So, yes, we've heard from a lot of rural partners that a lot of there's the surface heirs and the under the ground heirs and how much that complicates issues. While that direct research is not a part of our specific work, we do have a lot of partners that look at these types of things, particularly in the Appalachian region and in the Southeast. And so I can drop in this question in the chat here. Some of the links to those folks that we know work on those issues.
Yeah, it does create complications. Yeah, like I know in fracking and stuff, and it's in Pennsylvania, and they said it created complications about who owned what where. It just makes it the royalties and the land, but then under the land, it's complicated. Yeah, the rights.
Someone talked about the encumbrances from imposed second liens, how they converge on predatory practices where the homeowner does not understand the implications of sharing the proceeds from the appreciation of properties.
Yeah, and this is like a very, very specific thing. Just let me read through this question again. Yeah, so a lot of what we tried to do with our version of the Uniform Partition Heirs Property Act is get the court to rethink how it evaluates how, whether somebody, lives in a property, whether they've been managing the property, they've been paying the taxes, they've been taking care of it, whether they've pulled money out of the property by, putting other kinds of liens or encumbrances on it. And it used to be that the courts would ding that the occupants, or they'd charge them rent for the entire period that they're living in the property. And so it was another tactic that the speculators were able to use to strip all the wealth. And there's like, oh yeah, you lived in that property for 20 years rent free, so we're going to say that we're going to reduce your equitable interest by $500,000 to account for that rent. But these other encumbrances, now the courts are in New York, and I don't know how it's working in other places, are taking a much closer look at who's benefiting how from the different liens and things that are put on there. Reverse mortgages are a whole separate thing. And it's usually a lot of times when a senior takes out a reverse mortgage, I never recommend reverse mortgages to our clients in only very specific situations, because they're very expensive, costly loans, tons like really high origination fees, and also insurance and things like that. So the equity in a home gets taken by the bank very quickly. It escalates very quickly. And so if somebody does take out a reverse mortgage on their home, by the time they pass away, there's usually no equity left. And so, I kind of think it's a form of equity stripping by the banks. But the rare situations where there is still equity there, in order to sell the property, you have to get all the heirs aligned to sell it. Otherwise, it's just going to go to foreclosure. And if it goes to foreclosure, then we know that anytime there's a judicial sale, whether partition or foreclosure, you only get about 60% of the fair market value. And so a ton of the equity there is lost as well. And it's whatever speculator bought that property out of the foreclosure process is the party that gains the benefit of that equity.
The next question is, many people impacted by heirs property are middle-class households that may have too high of incomes for income-restricted legal aid services, but for who the cost of a lawyer may still be prohibitive. Can you share more about how you form partnerships with law firms or with law schools to provide pro bono services?
Yeah, well, in New York City, because property values are so high and median income is so high, we have a much higher threshold for who qualifies. And also at my old job, we were private. We weren't technically a legal services organization. We were something else. And so we didn't have the same income limitations that other organizations do, like federally funded legal services, for example. And so if we saw a middle income family come into the project and they couldn't afford legal services, we would still try to help them and provide the free legal services. But it is a problem, for sure. We were successful in getting a lot of public attention about these cases with law firms and like the big major law firms, and by stressing the racial equity issues involved here. And that was how we were able to get those resources. But these are, litigating these cases are very expensive and they're very resource intensive. So it's a challenge for sure. But I don't know if Natasha or Keith has anything more to add to that.
I would just well, we're not a legal organizations. We should not and do not give legal advice. But we did partner with Community Legal Services and help CDC in Central Florida, and the work that they've done to partner with Florida A&M University and with many pro bono attorneys in the region to support heirs property owners there. So I would recommend looking at their practices as well, because they've been very successful in the state of Florida in doing that work.
And this will be our last question. I'm sorry, everyone, but on the preventative side, have you engaged with housing counselors or realtors to include conversations about protecting homes from becoming heirs properties, for example, estate planning as part of the purchasing process?
Yes, and that's a great question. We've been doing a lot of work. We've been getting private and government funding to support support housing counselors all throughout New York City and New York State to be, first of all, train housing counselors to be aware of the heirs property tangled title issues so they can identify them and then refer them to legal services if it's necessary. But also, educating homeowners about the importance of getting an estate plan in place, and how to do that. So that's something that we're very aware of, and we're actively working to not just get funding, but also distribute the funding that we're getting.
Thank you. Again, thank you sorry, Keith, did you have something to add?
Oh, no, I was just gonna say that's one of the challenges of this. Heirs property is a dynamic thing. It's ongoing. So it's like you can never really get your head around it because it could happen tomorrow to somebody. So it's a preventative element to it.
Thank you. I want to make sure there's no other, I don't want to cut
Oh,
anyone
just
off.
one of the questions that came up, people keep asking if they'll be able to see this presentation afterwards or get the materials and.
Yes, thank you, Scott. I was definitely going to mention that. So the webinar has been recorded. We will send a link to the recording and a transcript of the recording to everyone that registered to attend. So that will be sent to you. Our panelists also actually created a one-pager. So with all the key points that they were mentioning in their slide decks, or in the presentation, that you're able to then use that to talk about it with those in your community, those within your organization, even for your own personal use. So want to make sure you have access to that information as well. And it seems like there are a lot of questions. Some have been, like I said, have been answered in the Q&A box. So please look to see if your question was answered. If not, feel free to reach out to me, and I can make sure that we I send over the questions to our panelists that they're able to answer the question for you. And like, just because we've seen what the great response has been to the information shared today, we might want to discuss like having a part 2 to this to make sure that we're able to get to some of these other key points that you guys have all talked about today. So again, thank you all for being with us. Thank you again to our panelists, Natasha, Keith, and Scott, for spending some time with us today. They put a lot of effort into creating this and being with us. So thank you again. And we look forward to seeing you at another Just Economy Conversations. Take care, everyone.
Thank
Thank
you.
you. Have a great day.